Not enough justice. Hey, y'all too quiet for me.
The right to protest is an umbrella term used to describe a number of rights protected under law, and, in particular, the right to assembly and the right to freedom of association. These rights form the tenets of South Africa's constitutional democracy and are crucial for accountability and advancement of all other rights. In the South African Constitution and in many international and regional instruments such as the African Charter on Human and People's Rights and the Universal Declaration of Human Rights. The African Commission on Human and People's Rights adopted guidelines which serve as a starting point to freedom of association and assembly in Africa. Those guidelines provide 10 key principles which will be set out in this video and explained by reference to the South African context. This means that when there's any doubt, there's a presumption in favor of the right to freedom of association and assembly. An example of how this applies in real life is that if you're trying to register an organization, your rights vest automatically. Any person who wants to challenge the registration of your organization bears the onus of convincing the state that you shouldn't be allowed to register. This principle means that laws and other steps relative to the right to protest should have the primary purpose of enabling the exercise of the rights. The focus should be on promoting the right, not curtailing or restricting it. For example, the Constitution is therefore framed in an enabling manner with a strong focus on ensuring that courts and tribunals protect them. On the other hand, one might consider the Regulations of Gatherings Act less enabling because it requires citizens to jump through several hoops to assemble more than 15 people in a public place, such as the need to give 7 days' notice. This principle ensures the participation of organizations such as community groups, non-profit organizations, and charitable organizations in the public sphere. The Non-Profit Organizations Act expands on this right and supports the contribution of civil society organizations. An example of the government failing to uphold this principle would be when the City of Cape Town refused monitors from the South African Human Rights Commission entry to the Strandfontein homeless shelter. This means that all constitution, legislative, administrative, and other measures must comply with regional and international human rights obligations. For example, the case of Nungwana versus the state declared that part of the Regulation of Gatherings Act, which made failure to give notice of a gathering a criminal offense, is inconsistent with the Constitution and thus invalid. This interpretation promotes fundamental freedoms and ensures that the RGA is compliant with international human rights instruments. This means that authorities with oversight, such as the police, should conduct their work impartially and fairly. An example of South African law failing to uphold this principle is that the Regulation of Gatherings Act allows police to use firearms to eliminate an imminent threat to life or property caused by a protest in more circumstances than international rules allow. This can be linked to the Marikana massacre, in which 34 minors were killed and 78 seriously injured whilst demonstrating. This principle means that procedures relating to the governance of associations and assemblies must be clear, simple, and transparent. An example of this in practice is that the Regulation of Gatherings Act sets out what you must do in order to hold an assembly and be compliant with the legislation. Similarly, the Non-Profit Organizations Act explains the steps you must take in order to register an organization. This principle means that all state decisions must be clearly laid out, with any adverse decision explained in writing, based in law, and challengeable by an independent court. In practice, this means, for example, that if you are aggrieved by a decision taken by the local authority in respect of your gathering or by the NPO Directorate with regards to the registration of your NPO, you can challenge the decision via judicial review. This means that any sanction imposed in relation to associations and assemblies must be proportionate to the gravity of the harm and applied only as a matter of last resort to the least extent necessary. An example of where South African law contravenes this principle is that the Regulation of Gatherings Act states that any riot damage will be the liability of the person that organized the gathering or every person that participated in the demonstration. However, the Guidelines on Freedom of Association and Assembly state that neither the organizers nor fellow participants of a public assembly shall be subjected to sanctions of any kind on the basis of acts committed by others. This element of the RGA therefore contravenes the guidelines. This means that where rights to associations or assembly are violated, the victim has a right to remedy. For example, under the Non-Profit Act, you have the right to appeal a decision to refuse to register your organization, and the appeal tribunal must hear your appeal within 3 months. This means that if there's a conflict between the provisions of the Guidelines on Freedom of Association and Assembly and other international or regional human rights instruments, the provision which offers the highest protection of fundamental rights should take precedence. In conclusion, everybody has the right to assembly and to association. As can be seen from this video, South African law in most instances is compliant with the guidelines.